This lesson is an introduction to the American legal system. We will be discussing preventive law as it relates to risk management, the study of law in sport, as well as legal research. Let's start with discussing what is preventive law. Now, your text talked about the difference between risk management and preventive law. Broadly speaking, risk management is a process by which organizations will identify risks in their immediate environment and work to manage or reduce those risks. However, what we have found is that a risk management approach is a very narrowed lens of legal liabilities and will often focus on personal injuries to their primary stakeholders, as well as property damage. However, in comparison, preventive law looks at all risks that could affect an organization's financial health. So it's a broader, holistic focus that will take into account any risks that could give rise to damage to a person, damage to property, but also damage to finances because of lawsuits. So if a organization is sued because of their employment practices, any breach in contract, intellectual property, any issues could give rise to a financial risk. So we are going to take a preventive law lens to this class and really look at the exhaustive list of risks that your organization could be exposed to so that we can work to mitigate those risks. The preventive law process is a 5-step process. It starts with risk identification. And as I just mentioned, preventive law is a exhaustive view of risk. And so you first want to explore all possible liabilities the organization is exposed to. You would consider your facility, equipment, employment, supervision, any concerns regarding your patrons, intellectual property and advertising, emergency and crisis concerns. So it is a very comprehensive audit of the entire organization and how it functions. And then step 2 is for every single risk that you identify, you should determine the probability, severity, and magnitude of that risk. The probability is the anticipated frequency of its occurrence. From low to high, how likely is it to occur? A tornado? Pretty low. An ankle sprain? Pretty high in sport facilities. Severity is the potential degree of injury if it were to occur. Going back to if a tornado were to run through your facility, high severity in terms of the damages, but an ankle sprain is low severity. And then the magnitude, the number of possible people that would be injured if this risk were to occur. Let's stick with our tornado example. And if that came through your facility, a significant number of people would be affected, whereas an ankle sprain is most likely just affecting one person. Now, this risk assessment will inform how you actually treat and manage those risks. So it's a really important step. Next is risk evaluation. And this is where you will prioritize how you treat your risks based upon the organization's mission and the importance of the activities. So how critical is this particular aspect of your organization to your organization that is giving rise to risk. So for example, in intramural sports, many collegiate recreation departments do not allow tackle football because it's just too high of a risk and it's not worth it. So they'll use flag football in their programming. And then once you've evaluated the risk, you will develop a plan. And there are 4 primary strategies for how you will treat your risk. There's risk elimination, where you completely eliminate the risk, the source of the risk. And it's typically only appropriate if there is high probability, severity, and magnitude. So the risk outweighs the benefits of retaining the activity that gives rise to the risk. And then there is risk retention, where you just accept the risk and assume the responsibility because it will most likely result in little damage. There is risk transfer, where you're shifting the risks to another party, such as through insurance or through use of an independent contractor, or even contractual provisions like having participants sign waivers. You're shifting the responsibility for the risk to someone else. And then there's risk control. And this is where you are developing strategies to try and reduce and minimize the risk. And typically we see in sport that risk control is always going to be a part of the plan. So often it's a combination of these treatment strategies. And then you'll implement the plan. So making sure that the plan is integrated within the organization's strategic plan, and that will involve developing policies and procedures, designing training programs to train your staff on how to implement the plan, and then evaluating the plan to make sure that it's working. Are you effectively reducing, controlling, transferring, or eliminating risk? Now, I want you to pause the lesson and just take a moment to contemplate. How do you think engaging in preventive law can reduce an organization's legal liability? Let's now shift to the study of law in sport. Now, this class is called sport law, but there isn't necessarily law that's specific to sport. So throughout this course, we will be examining a wide range of legal concepts that are relevant, but not necessarily unique to sport, but really important principles that you should know before you enter the sport industry. Now, broadly speaking, law is a collection of rules and regulations that will inform the behaviors of the community as well as those of legal authority. And there are four different sources of law that you'll see on this screen. There's common law, constitutional law, statutory law, and administrative law. Common law is a collective body of case law. So common law and case law are words that are often used synonymously. Case law will establish precedent for future cases. So the case studies and sport management textbook that you are reading and that we're working from has court decisions. So all of those case studies are court decisions. It's the final decision from the court regarding that case, and that is an example of common law. It will establish precedent for future cases. And precedent is essentially, what was the court decision? So how was the law applied in this particular case? That becomes a rule that must be then followed by subsequent courts of a similar or lower rank involving a case presenting a similar legal problem. Now, courts are guided by what's called the principle of stare decisis, which requires them to utilize precedent when making their decisions. Stare decisis is Latin for to stand by decided matters. And essentially, parties that are filing a lawsuit want to have faith in the legal system, that it is an even-handed administration of justice. And so for courts to be fair and courts to be consistent, it's really important that they follow similar rules that have been followed in the past. An example, well, I'll give you an example of common law in just a moment. And then there's constitutional law, which sets forth principles of the government and actually limits the government's power in order to protect private citizens. So examples of the Constitution that we'll be talking about this semester are the First Amendment, the Fourth Amendment, the 14th Amendment are all examples of constitutional amendments that are relevant to sport. Now, the federal government has a constitution, the US Constitution, and then each of the 50 states has its own constitution. And then there's statutory law that is written and adopted by legislatures at all levels. So we'll see it at the municipal, county, state, or city, state, and federal level. And statutes are only valid in the area governed by the authorizing legislature. So if a statute is developed at the city level, then it only is relevant and valid in that particular city. Examples of statutory law would be tort law, contract law, Title IX are all examples. Another one, Ohio, does not have a statute that requires an AED at school athletic events or health clubs. However, Indiana does have a statute that stipulates that. So it's really important to be mindful of who is the legislative body that are writing and enforcing these statutes. And then there's administrative law, which are rules and regulations that are adopted and enforced by specific government agencies. And so government agencies, examples would be like the National Labor Relations Board that will enforce all labor laws, like fair employment practices. I'm going to switch my screen to show you a few examples. So on my screen now, you will see, here's an example of case law. So this is a case, Eddy versus Syracuse University, and this is the published court opinion. And how the law was applied in this case will establish precedent for how the law should be applied in subsequent cases within the state of New York that relate or that involve a similar legal problem. And then the next slide we'll see First Amendment. It's a big one: freedom of religion, expression, assembly, the right to petition. This is an example of a constitutional law. And then, as I had mentioned, Title IX, which is a very relevant law pertaining to gender discrimination. And it is a statute that just an example of a federal-based statute. And then here's an example of administrative law. The United States Department of Labor is a governmental agency that enforces all occupational safety and health administration policies, which is particularly relevant related to COVID. So those are a few examples of different laws. All right, let's go back to our PowerPoint. Related to statutes, I just wanted to give you an idea of how the different branches of government work with these laws. So you'll see that the president will propose a statute, but it's the Congress that passes the statute, and it's the federal courts that will enforce those statutes in case law. And then administrative agencies are going to really be focused on the day-to-day enforcement of rules and regulations. When thinking of common law specifically, as you saw in the previous slide, it is the judicial branch or the of the government that will interpret and enforce statutes in a court of law. And so a court system, let's talk about what that looks like. It's a structured collection of individual courts. Now, there are three different court systems. There's a state and federal court system, and then there's also an administrative court system that's specifically focused on administrative rules and regulations. For the majority of recreation and sports cases, they are filed in the state or federal court system. So we're going to focus on those two in particular. Now, the federal court system and the state court system both use a hierarchical approach, which means that a lawsuit or a legal case will always originate in the lower courts and be appealed to the higher courts. And so at the federal and the state court system, there are three levels of courts. The federal court system, the lowest level is the district court, where a lawsuit would be filed. And then if a party to the lawsuit who loses does not feel that the law was properly interpreted or applied at this lowest level court, they may appeal the case to the next level court. So in the federal level, that would be the Court of Appeals. And they would be now the appellant, and they are filing based upon legal error. And then once again, whoever loses at the appellate court level, if you feel there was legal error, you can appeal the case to the highest level. So when we're thinking about the state court system, we start off with the trial courts. And I wanted to include this image of the Ohio judicial system because unlike the federal court system where the lowest court is always called the district court, at the state court system, the trial courts kind of have a variety of names. And so in Ohio, we see Court of Common Pleas, municipal court, county court, court of claims, mayor's courts, all of those refer to trial courts, so the lowest level. So I just wanted to give you a heads up that state court system, the lowest court, which handles civil cases, may have a number of different names. So then you would appeal to the Court of Appeals, which at the federal court system is called the circuit court. At the state court system is called the appellate court. Focusing on the state court system, if a case were to be appealed past the Court of Appeals, it would be heard by the state Supreme Court. Now, once again, at the state Supreme Court, if the party that lost the lawsuit felt that there was legal error, they do have a right to request the case to be heard at the US Supreme Court level. So the US Supreme Court level within the federal court system is considered the court of last resort, but there's no guarantee that you will be heard by the US Supreme Court. You will request through a petition to appeal your case to the US Supreme Court through what is called the writ of certiorari. However, the petitions that are granted is like less than 5%. So it's pretty rare that cases make their way to the Supreme Court. Typically, it is the cases that are going to change the law, like major cases that are going to change our legal landscape. Those are the ones that will make it to the US Supreme Court. And then within these tier systems, you might see certain classifications of courts, such as criminal courts, where the government will file the complaint, civil courts, where the injured party will file the complaint, and then juvenile courts, which specifically focus on the needs of youth. When filing a lawsuit, the party must first determine which court has jurisdiction to hear the case in order to know, all right, should you file it in the trial court, like the state trial court? Should you file it in the federal district court? You really need to know which court system has jurisdiction, which is their ability to hear a case and provide a remedy. Because if you file your lawsuit in a court system that does not have jurisdiction, it can be dismissed. Now, there are two different types of jurisdiction, or primarily, there's personal jurisdiction and subject matter jurisdiction. Personal jurisdiction, focus on the word personal, it's power over the parties that are involved in the case, whereas subject matter jurisdiction, as you would anticipate, is power to hear the subject matter of the case. So it's specifically focused on the content of the case. Now, personal jurisdiction, a few examples of which court system has jurisdiction. When it comes to the state court system, they will have personal jurisdiction, so power over parties that will reside in the state, so both the plaintiff and the defendant reside in the state, or if both parties conduct significant business in the state, or have just sufficient contact with the state. So the parties are heavily engaged in the state. The state will have personal jurisdiction. For subject matter jurisdiction, the federal court system will have jurisdiction when cases involve federal statutes or the US Constitution, so any federal law, the federal court system will have jurisdiction. If the remedy that's being requested is an amount that exceeds $75,000, so just think big money, the federal court system will have jurisdiction. And then also, understandably, if the parties live in different states, like which state has personal jurisdiction, in that case, the federal court system would have jurisdiction. Now, there are some instances where both the federal and the state will have jurisdiction. And in that case, the plaintiff who files the lawsuit has the ability to choose which court system they want to file in. Usually it's based upon whichever system has laws that favor their particular case. And if the lawsuit is filed in the state court system, the defendant can always opt to move the case to federal court. So we talked a bit already about the parties in a lawsuit. A lawsuit or legal case is brought about when a person, so this would be the plaintiff, believes that they have been wronged and they want a remedy for this wrongdoing. And so they will seek that remedy from the court. Now, the parties in a lawsuit are the plaintiff and the defendant. The plaintiff is the one that is initiating the lawsuit by filing the complaint. It can be an individual or a group. If it's a group, it's a class action, but they have suffered harm and want some type of remedy from the court. Typically, it's money that we see in sport cases. And then there's an appellant and a petitioner. The appellant is the party that files the appeal to the middle level. So that's either the circuit or appellate court. And then the petitioner is the party that files the petition to the Supreme Court. Now, I want you to know that this can flip-flop. Like if the plaintiff filed a lawsuit and they won, well, then it would be the defendant who appeals the case and becomes the appellant. So the plaintiff, the appellant, and the petitioner, they are the parties that are bringing the case before the court. And then the defendant is the party against whom the claim is filed. They may have been responsible for harm. At the appellate level, they would be called the appellee. So the party against whom the appeal is filed. And then at the Supreme Court level, they are called the respondent. Once again, it's the party against whom the petition was filed. There are 4 stages of a lawsuit. I love this graphic because it just kind of is a nice way to walk you through all of the different parts of a lawsuit, but we will discuss each phase. Starting off with the complaint. All right, so prior to filing a legal complaint, a plaintiff must establish legal standing, which is the right to actually file their lawsuit. So the first thing is they need to establish that they have sustained a harm. Now, if the minor is the person who sustained a harm, then their parent or guardian can file on their behalf. But it must be the injured party who files. The court must have the power to provide a remedy, which means that they have jurisdiction over the parties or over the subject matter. And then the plaintiff has to have an interest in the outcome of the case, which I feel like that's just kind of a given. When filing the complaint is essentially a written statement that alleges all of the plaintiff's arguments. You will see on the graphic on the slide, this is an example of what the complaint document would look like. So they're outlining all of their arguments, the legal theories involved, and then the remedy that is sought. The complaint will commence the legal process, which just means to start it. And in response, the court that receives the complaint will issue a summons to the defendant, which essentially informs them of the complaint that was filed and instructs the defendant to file a response. So in response, the defendant will file an answer to the court, which will respond to every single allegation in the complaint. They'll provide a response, and typically they'll need to file that answer within like 30 to 45 days. So after the complaint, summons, and answer, we move on to discovery, which is a period of time where both parties can obtain information about the incident in question to be used as evidence in trial. Now, I wanted you to know that during this time of discovery, a case can be settled out of court. In the sport industry, we actually see a majority of claims settled out of court during discovery. Like, it doesn't even make it to trial. However, if we are gathering evidence during discovery to be used as evidence in trial, often information will be obtained through affidavits and subpoenas. Affidavits, which you'll see in the mock trial documents, are sworn statements by witnesses of what they observed. of the event, whereas a subpoena is a court order compelling a person to appear in court as a witness or produce documents that can be used as evidence in court. And then at the end of discovery, the parties will move into the motion phase to prepare for the trial. Now, a motion is a formal request to the court for a specific action. You'll see on this graphic pretrial motions, different examples and their purpose. Some of the motions that we see pretty common are a motion for judgment. And essentially, this motion is made where the party is alleging, so motion for judgment is would be made by the defense, and they are arguing that the plaintiff has not provided sufficient evidence to meet their burden of proof, and therefore the defendant is requesting that the judge give a directed verdict in their favor. Another example is a motion to dismiss. So if that plaintiff does file the lawsuit in the wrong court system that doesn't have jurisdiction, the defendant can motion to dismiss, or if the case is past the statute of limitations, which is the period of time where the plaintiff has legal standing, then the case can also be dismissed. Another common motion is for summary judgment, and this occurs pre-trial, essentially when one party believes that there are no questions of fact. Like, there doesn't need to be any deliberation. We don't need to be presenting different cases and different evidence in court. The facts are clear. There are no facts or evidence that's in dispute. And so the judge should be able to make a decision as a matter of law before the case even has to go to trial. So those are some common motions that we might see that happens before a trial. But if a case doesn't settle out of court, it will move to the trial phase. And for a trial, what would happen, which we'll see in the mock trial, is typically the plaintiff and defendant will both make opening statements presenting their legal arguments, and then they will present their case where they are examining witnesses and cross-examining the opponent's witnesses, potentially making motions throughout the case for the judge to make a certain action. And then after the motion, or after they present their evidence and their motions, the parties will move to closing arguments, really summarizing their case and their evidence. And then the judge will return a verdict, either in favor of the plaintiff or the defense. If the defendant is found liable, damages are typically awarded to the plaintiff in the form of monetary compensation. However, there are alternative options to a trial. And I have a graphic that I think does a nice job of highlighting all of these options. So settlement, which I indicated happens a lot in sport, where parties will settle out of court, is where there are negotiation between parties to reach a result that both sides agree with. It doesn't involve a neutral third party. Both sides just basically negotiate for whatever bottom line money amount to be paid. And then there's alternative dispute resolution options, such as arbitration or mediation, which you'll see on this slide. Arbitration is kind of similar to a trial where a neutral third party will serve as judge and provide a final decision, but it's a lot faster. And you can save money that way by not going to trial. A lot of contracts you'll see stipulate a preference for arbitration. And then mediation is one in which a neutral third party, it doesn't act as a judge, but they help mediate the settlement. So they facilitate negotiation between both parties and help both parties work towards a settlement. And we often see mediation in sport law cases just because it can preserve the relationship between the parties. Now, as mentioned previously, if the losing party believes that there was legal error, so the court misinterpreted or they misapplied the law and they want their day in court again, they want the court decision to be reversed, what they would do is they would appeal their case to the next level. So that would be the appellant. if you're going to the circuit court or court of appeals, or you would be the petitioner if you are petitioning your case to the state or US Supreme Court. And what's going to happen at this appellate level is that the appeals court will review the facts of the case that were established at the lower court level. So no new evidence is being presented here. They're just reviewing all arguments and evidence that were recorded in the lower court level to determine whether that lower court's decision was correct in totality, correct in part, incorrect in totality, or incorrect in part. Basically, did they get it right? Did they interpret and apply the law correctly to this particular case? Now, if at the appeals level, if the lower court's decision is correct in totality, then it will be affirmed. And the appellate court will mandate that the judgment of the lower court be executed because it's affirmed. However, if the court finds, so the appellate court finds that the lower court decision is incorrect in totality or in part, that means that they did get something potentially wrong, then the court will remand the case back to the lower court for further proceedings. Now, if the case was found incorrect in totality, the case would pretty much be entirely heard again or presented again. However, if it's only incorrect in part, the court of origin, so the lowest court, may only be asked to hear certain parts of the case a second time, whatever parts that they may have gotten incorrectly. So to apply what you have learned in this section of the study of sport law, I encourage you to review the Eddy versus Syracuse University case in your textbook and outline the 4 stages of a lawsuit. So feel free to pause this lesson if you would like to engage in that activity. Moving on to legal research. The purpose of legal research, you'll see on this slide, is to analyze the law in order to proactively anticipate legal issues so that you can prevent those issues from ever arising, or that you can respond to the legal issue once it has arisen. As we spoke about in preventive law, legal research is a critical part of preventive law because it involves identifying any potential legal risks that an organization is exposed to so that the organization can hopefully prevent those legal risks from occurring. But if they do occur, you can respond appropriately. So this involves legal research because you need to understand the law in order to understand the liabilities your organization is exposed to. Another purpose of legal research is just to maintain knowledge and awareness of current and emerging legal developments because the law is constantly changing. We're constantly seeing new cases that impact sport management. And so you need to have just at least a general understanding of how the law is changing, what are new laws that are being introduced that impact our practice. When you are engaging in legal research, what you need to do is to acquire legal sources of information in order to understand the law, learn about it so that you can apply it to your field. Now, there are 2 different sources of legal information. There are primary legal sources and there are secondary legal sources. Primary legal sources represent the actual law. So it is the law. The law is a primary legal source of information. Therefore, only primary legal sources can be relied upon when you are utilizing the law. So it's your best information is always going to be primary. Whereas secondary sources, those sources will explain, interpret, or comment on the law. Secondary sources should never be solely relied upon as legal authority because they're secondary. It's an interpretation of the law, which can be subject to human error, let's be honest. And so secondary sources, which we'll talk about in a moment, your textbook for example. Secondary sources are great resources for the layman, for us who do not have a law degree. It helps us understand the law so that we can apply it to our own practice, but a secondary source of legal information would never be used in a court of law, for example. So let's talk about primary legal sources. As I mentioned, a primary legal source, it is the actual law, so actual statements of law. Therefore, constitutions, the state statutes, federal statutes, court cases, so common law, administrative regulations and rules, all of those four sources of law, which we talked about, are examples of primary legal sources of information. I wanted to focus on common law just so that you can read a case and locate it in the library is important, as we'll be using cases throughout the semester. So a common law are court decisions that are published in reporters. Now, not all court decisions are going to be published. However, typically we will see the federal court decisions, and then some federal court decisions are going to be published. And then at the state level, usually it's the appellate court decisions and the Supreme Court decisions that are published. But essentially, a court decision is the judge's final judgment and their reasoning. So it's going to present the facts of the case, it's going to present the legal rules that were interpreted and applied by the court to come to a determination on the case. So that's what a court decision is, and that's what would be published. And you can locate these cases by using a case citation. So as you will see on this slide, there are several pieces of information in a case citation. Think of a case citation as a reference. It enables you to locate the case in a book in a library. And so at the federal, for all federal cases, a case citation would involve the volume. So that is the volume of the reporter, the publisher, which is the name of the reporter, and the page number, which is the first page in the reporter where you can find the case. In the federal courts, typically the reporters often have federal in the name, so that's helpful. So it'll be like the Federal Supplement or the Federal Reporter, or the US Supreme Court reports. Those are all examples of names of reporters, which is essentially the publisher. And then at the state level, you'll also see volume, publisher, page number. So once again, what's the volume of the book? What's the name of the book or the reporter? And then what's the first page where you can find the case? But you'll often also see the state and the year. So if you see a state and year in parentheses, that is a state case. Or a case that went through the state court system. And then also attached, you may see the names of the parties to the case. But what's most important that I want to draw your attention to is the volume, publisher, and page number. That right there is the case citation. So in this example, we'll see that Frank Thomas and Company filed a lawsuit against Charles Limited, and this court decision can be found in volume 253 of the Pacific third series. So this is a regional state reporter, and the case can be found on page 452. And because this is a case that went through the state court system, you'll see here that it was the Kansas Court of Appeals, and the court decision was made in 2005. All right, then moving on to secondary legal sources of information. They are so helpful for us as sport practitioners, so helpful. So when you think of like dictionaries and encyclopedias, think of that in the law context. So it will help you understand legal terminology and legal concepts. A treatise is a fancy way of saying textbook, just so you know. So your textbooks for this semester are examples of treatises. And then we have legal indexes, which helps you also understand legal terminology, identify relevant case law pertaining to the laws. law review articles are articles that focus on a particular legal issue and will identify relevant laws pertaining to that issue. There are some journals that only focus on articles related to the law. And then there are electronic web searches that can allow you to look up these secondary and primary legal sources. This graphic on the side you'll see is Nexus Uni, which is LexisNexis Academic, which we have access to at Ohio State, and it will allow you to look up cases and journal articles and textbooks. It's a really great resource that can help you in your legal research. And then moving down to the research process. So how do you actually engage in legal research? Now, it's a non-linear process, meaning that as you gather information, you will find more information and you'll have to go back. So as you're reading like a legal index, you'll come across new cases or new laws that are pertaining to the legal topic you want to study. So then you go back and you have to read more. And so it's a bit of a circular process, but really the goal of legal research is to gather information and gain more understanding about how the law is developed and how it applies to your specific legal issue or topic so that you can understand, you can understand your legal issue better by understanding how the law applies to it. So the research process starts with having a legal topic or a legal issue that you want to learn more about. And your goal is to retrieve relevant sources of legal information so that you can understand your legal topic better and have a grasp of how the law applies to your legal issue that you can then take and apply to your sport management practice. So the first step is identifying the problem or issue. Like, what are you interested in studying? What is the legal problem? What is the legal issue that you're going to focus your attention on? And then you want to consult encyclopedias, dictionaries, and treatises. This will help you gain familiarity with the general area of law. So we actually do start with secondary sources so that we can better understand the legal problem or the legal issue, just have a general understanding of the laws that are relevant, but also these secondary sources can help identify relevant cases. Like as you notice in your textbook, you'll be reading different cases are cited throughout that are relevant to that chapter. So then you'll take those cases that were identified as relevant in your textbook or in the encyclopedia, and you'll locate those cases using the case citation. And then you will read through those cases for step 3. So you're going to read the case law and become familiar with how the court system has enforced the law in cases that pertain to your legal problem or your legal issue. So you'll read and summarize those cases. When you are reading and summarizing those cases, you'll locate additional cases. So I hope you're starting to see the cyclical process because those cases will use precedent. The judges will use precedent in order to apply or interpret and apply the law in that case. So then you will take that precedent, locate those additional cases that were cited as precedent and read through those. And then you will shepherd-ize those cases, which is essentially determining whether that law is still good law. Now you'll see on the screen these shepherd citations, which basically indicates, hey, has this case been cited in subsequent cases? And when it has been cited in subsequent cases, has it been affirmed? Has it been reversed? Has it been used with caution? Has it been disregarded? You want to make sure you're still relying upon good law when you're engaging in legal research. And then you'll look up if there are any constitutional or statutory laws that are relevant, that are identified in these cases. You want to read through those just to make sure you have familiarity with those laws. And then you will organize your information in a way that helps you to understand the legal problem or the legal issue and take that new knowledge and apply it to your field. That is the nuts and bolts of the research process. I encourage you to explore the Nexus Uni Research Database. You can access it through the OSU library page. And just look up primary and secondary legal sources of information that might be relevant to your sport law project, because you will be engaging in legal research throughout the semester, but heavily for your sport law project. And it will be good to have a better idea of how our library and its resources can be beneficial to you.